Hello, everyone. Welcome to our webinar here today in honor of Pride Month. We're going to give it just a minute before we actually dive in. We always want to give people a chance to sign in, and we know it takes some time. It takes us time to get all set up too, and we're giving these webinars. So I want to give you a moment to get settled in, get a piece of paper out. We, of course, encourage you to share the word, subscribe to our Gilfix Law YouTube channel where this is or will be posted, depending on when you're watching it. And I'm really excited to be presenting here with my esteemed colleague, Nick Klingenberg, who's a fantastic attorney. He's actually going to be leading most of this. So we're going to get to this in just a moment. I see a few people signing in. And we will get to a couple questions at the end. If you have questions, please submit them via the Q&A function, and we'll try to get to some at the end. We have a lot to get through, so we're going to kind of charge through. But if you have questions, submit them via the Q&A function. And again, we'll try to get to as many as we can. And we'll get started in just about one more minute to let people join. But anything you want to add, Nick, as we get ready to get started?
No, I just want to say thank you for inviting me to present, and I look forward to hopefully sharing important information to all the people who are attending.
Absolutely. And we're going to be talking about an issue that is challenging, for the LGBTQ community. There are unique planning issues, and it's hard to find good information about that. And so that's really our goal today, is to give you kind of an overview of what you need to be aware of. And if this applies to you, pay attention. If there's other people in your family who could benefit from this, please share, spread the word, and we want to make sure that the community is educated. So I think on that note, let's jump in. So an official welcome to our webinar here today. This is in honor of Pride Month, estate planning for the LGBTQIA community. We're very excited to share this presentation. We're going to talk about issues specific to this community and the planning issues that families need to be aware of, no matter what your status is: domestic partners, married, none of the above. There are issues that everybody has to be aware of, and that's what we're here to present today. So as we get started, just about us. So I'm Mark Gilfix. Some of you may know me already from other webinars or from our firm. Many of you may know Nick Klingenberg. He's fantastic. So Nick has been with us how many years now?
I'll be starting 6 in September.
6 years.
So close. Yeah, time flies.
And yeah, Nick is fantastic, and it's been such a joy working with him. We get so many great notes from clients about how awesome he is. But Nick is, he started in New York. He's a rising star super lawyer. He graduated from St. John's University School of Law, but I think the most importantly, he's been immersed in these issues for the last how many years in total practice now? So I guess that's...
Yeah, I was admitted to practice in 2016. So 2016. It's been, that's my 7th year of practice.
Yeah, despite his youthful appearance, many years, and he's worked with hundreds of families with us, and he just really knows his stuff. And these issues, I think, are personal. Nick, he really understands the planning issues facing families in this community. So Nick, why don't I can turn it over to you. Actually, quickly about our firm. So many of you may be familiar with us, but our firm, Gilfix La Poll Associates, we're based in Palo Alto, but we serve clients throughout the state, from San Diego up to Wairika. We are very proud of our legacy. We've been in the Bay Area, really in California, for nearly 40 years. We've served literally tens of thousands of individuals, thousands of families, in the areas of estate planning, special needs planning, long-term care planning, elder law, litigation related to this. This is what we do. We don't do a lot of different areas of law. We don't really do business law in other areas. We focus on legal planning for families, the issues that face families. That's what we're all about. We're very proud of our involvement in educating the community. We've been featured in the Wall Street Journal, USA Today. We do a lot of outreach and education. We write books on these subjects. And our goal is to provide extraordinary value and peace of mind. So on that note, let's dive into what we're going to be discussing today. And Nick, why don't you take it from here?
Thank you, Mark. And yes, like you were saying earlier, these issues are pertinent to me as a member of the community. So this is an important webinar personally, and that's why I was eager to present it when given the opportunity. So in terms of our agenda, here's a brief overview of what we aim to discuss. First, I'll give a brief overview, let's call it History 101, about where things stand in terms of the different rights and basically focused from a planning perspective on the definition of marriage and to what extent it's available, along with other opportunities or alternatives that could come into play within the community. And I will say just the community, referring to the LGBTQIA plus community as a whole. I'll turn it back over to Mark so we can go over some basics of estate planning that apply no matter whether you're a member of the community or an ally or what have you, your status and family dynamic. There are still baseline foundational planning documents that have to be in place. And then we'll turn back and we will talk about critical planning steps that apply specifically to the members of the community, issues and nuances with respect to planning for the community. And then we'll talk about how to protect assets, and this is across the board, from divorce, lawsuits, and future estate taxes, which no matter whether you're a member of the community or not, apply to anybody. We've all been divorced, we've all had a lawsuit, so it's something that can apply across the board, and those topics are very important to everyone. So starting with the quick history. So prior to November 18, 2003, we didn't necessarily have to analyze these issues like we are going to in this webinar because there was no option for there to be a legal marriage in the United States. On that date, we had the first state, Massachusetts, my home state, which by litigation was obligated to start issuing marriage licenses to same-sex couples. That started a trend that continued effectively until 2015. We did have a law in the book known as the Defense of Marriage Act, which was a federal law that prohibited the federal government from recognizing a state-level same-sex marriage. That law was struck down in 2013 in the Windsor case. We have a picture of Edie Windsor here on the slide. That put legal same-sex marriages at a state level on par with all other marriages from the federal perspective. And we'll talk about how that was important when we get to concepts like the unlimited marital deduction, which was what was at issue in the Windsor case. Then finally, sort of ending the saga here, on June 26, 2015, in the Obergefell case, the Supreme Court ruled that same-sex marriage could not be outlawed in the United States, meaning that any remaining bans, and at that time there were only 10, any remaining bans were struck down, and no matter where you are in the United States, you can, same-sex or opposite sex, enter into a marriage. Importantly, those two cases, they gave same-sex marriage equal legal status as opposite-sex marriage. So, this will be a theme that comes up in the context of the webinar, is that if you're married, whether same-sex or opposite sex, the same rules effectively apply. It's some of the alternative family structures that require additional planning. And to that point, if you are married, no specialized planning is needed per se, but as we'll discuss, still baseline foundational steps you have to take for your own core plan. As an aside, and not to get into politics at all, but there are some concerns with respect to where some of these rights are headed. I think for the purpose of our webinar, which will be California focused, we don't necessarily have to worry about any storm clouds on the horizon. But if anyone's joining from other states or other jurisdictions, we may be taking a change in approach as time moves on. But this webinar will focus on the law as it stands today. Mark, I'll turn it back to you for the basics of estate planning.
Yeah, so this really applies no matter your family structure, whether you're single, married, domestic partnership, or just in a long-term romantic partnership with no definition or legal arrangement. Really, everybody with any assets needs 3 core documents. And that's a revocable living trust. Related to that, there's a pour over will. So a trust really takes the place of the traditional will. Now, why would you want a trust versus a will? Well, really the key is staying out of the courts. So if you just have a will, even if it's valid, even if it's done right, well, one, a will doesn't help you at all while you're living. Your named executor can only step in after you pass away to oversee things. And 2, if you have any reasonable assets, if you own any real estate, if you have over about $150,000 in other assets, your estate's going to get stuck in the courts. And the probate process in California, I had a client last week who said they were involved in a probate that lasted 4 years. It's not always that long, but you do not want to get stuck in the California court system or any state's court system. Having a living trust keeps your affairs out of that. When you pass away, your assets pass without needing to go through the courts to your loved ones. And there's a lot more structure we can build into trusts. We also create a pour over will, which is something that says, hey, if I screwed up and didn't put some assets in my trust, that's part of the process. put it in my trust. So it's kind of a safeguard. So really a trust is much better than a will. Everybody needs an up-to-date general durable power of attorney document. This governs day-to-day finances. So imagine if you're incapacitated, can't manage things for yourself, who can step in to deal with taxes, to deal with real estate issues, to deal with social security issues, your retirement accounts. Someone needs the authority to step in to deal with that. And we usually recommend that you have a pretty sophisticated one, just to give someone the power to do whatever they need to do to protect your assets in case you're out of it for a while. And lastly, an advanced healthcare directive. So this is, what if you're in the hospital, can't speak for yourself? Who can make decisions for you? Who can communicate on your behalf? And what would you want in those situations? So this is a document where you can authorize people who you trust to step in for you, to view your medical records, to talk to doctors on your behalf, and the hospital or doctors will listen to them if you have this document in place. And you can also communicate what your wishes would be. Like, what if you're in a coma and you can't get out of? Do you want to be kept alive with tube feeding? You can say, hey, no, I want to be let go, or keep me going, whatever you want. You can take this burden off of your loved one's shoulders and communicate to them ahead of time what you'd want. So all these documents are really designed to keep you out of the courts. Because if you don't have a power of attorney, if you don't have an advance directive, and you are incapacitated in an accident or seriously ill and can't manage things for yourself, well, your loved ones have to go to court, and they have to get something called a conservatorship or guardianship, and they have to have a judge give them the authority to step in, and that's an expensive and painful process. So no matter your family situation, get these in place. So I'll turn it back to Nick to talk about, again, how these affect the community and the specific steps you need to be aware of.
Yes, thank you, Mark. And in terms of analyzing, again, those 4 key documents critical for everyone to have. But when we talk about issues that are unique to the community, I tried to develop a matrix so we could walk through some of the decisions and some of the points that have to be considered as we talk about estate planning within the community. So the first question, and this goes to what I explained before, is about how presently same-sex or opposite sex, if you're in a marriage, it's a marriage, and there's no real difference between the type of marriage you're in. So if you answered affirmatively, yes, I'm married, no particular complexities by reason of being a member of the community or being a same-sex couple, but you still do need a foundational and comprehensive estate plan. If you're not married, then we're in a situation where we need to have some specialized planning, to deal with that fact and to make sure your wishes are what you want them to be, notwithstanding the fact that you're not married. For a domestic partnership, which I'll explain in a moment about what that is and how it operates, it is an interesting hybrid in that from a federal perspective, it is if you're unmarried, but from a state perspective, it is if you're married. So because of that hybrid quandary, we want to have some additional specialized planning, and that may be necessary as we develop your plan. The same would apply if you have children. So this is across the board. If you have a child, especially a minor child, there's going to be planning required to protect that child and make sure there is a person available to make decisions and to parent that child if you were to pass away while the child was under 18. So specialized planning may be necessary there. And particularly with respect to the community, we have some alternative family arrangements. Maybe you have one child who's not adopted by one of the members of the couple. So there's additional planning necessary in those kinds of scenarios. And we'll talk about what that planning is in just a moment. So turning to an unmarried couple, I thought it would be easy to go through these with an example. So we'll be using Casey and Taylor throughout this presentation. And we'll start here by assuming that they're unmarried. So they're unmarried individuals, they have no children, and they also have no planning documents. So to play out the scenario, and this is a worst case scenario, what if something were to happen to Taylor? What people may not realize is that even though you may have a life partner who you've spent 40 years with, absent some formal document or a marriage certificate or a partnership certificate, Casey, who is the life partner here, has effectively no authority over Taylor. Casey's not entitled to share in any of Taylor's estate and is going to be omitted from any kind of decision-making with respect to Taylor's affairs, which personally, if that happened to me and my now spouse, but if we were unmarried, that would be devastating to the non-incapacitated or to the surviving member of the couple. Additionally, there would be huge property tax issues because as an unmarried couple, Casey and Taylor, the transfer of property is not something that's exempt from reassessment, meaning that property taxes would go way up. And depending on the size of Taylor's estate and the fact that we don't have a spouse, there could be an estate tax that would have been avoided through something known as the marital deduction, which we'll talk about in a minute. So on balance, if we look at this plan and we play out the worst case scenario, definitely a sad situation for this family to be in. How do we fix that? So here is what they should have done and what would have made the plan a much more optimal situation. So because they're unmarried in this scenario, they would each have their own planning documents. So as Mark described, a trust, a power of attorney, a forward will, a healthcare directive for each of them. And commonly it would be what I call an I love you trust, basically a trust that says, Taylor's trust would say, I leave everything to Casey and vice versa. That would provide protections to the non-spousal beneficiary. Unlike in the prior example, Casey could inherit the whole estate and not have to worry about the assets going to someone else who was not part of the family dynamic. Same for the power of attorney and the healthcare directive. Those are critical in this scenario because otherwise Casey, as the non-spouse, would not be able to make decisions. You could have some estranged family member coming in to make decisions about Taylor's life support or something like that, which again, devastating for the non-incapacitated partner and something that could be avoided entirely with a comprehensive estate plan. On balance, leaving a much happier scenario in this example. Even with the basic estate plan that I just outlined a moment ago, there are additional issues that would have to be explored for this unmarried couple in this example. Primarily tax. We've got three taxes that always come up: property, capital gains, and estate. So as I explained, property tax, if you are unmarried, that's not a permitted transfer of the property tax base between non-spouses, meaning we would have to take some additional planning steps to make sure the surviving member of that life partnership would be able to enjoy the low property tax base of the couple. Capital gains tax, same thing. When we talk about a step up in cost basis, that would not apply for the survivor's assets, meaning only the deceased person's assets would get a step up. It would be much more advantageous if some planning could be done to capture a full step up. Finally, from an estate tax perspective, you see that I have Warren Buffett on the screen here. It was actually fairly difficult to find a famous billionaire who's still married, but he is one of them. That is his wife, who is known as Astrid Manx. So I don't know if she is a citizen. Let's assume she is for this purpose. Basically, under the unlimited marital deduction, Warren could leave his $93.4 billion. That was today's net worth figure for him. He could leave all of that to her, and there'd be no estate tax to pay. Great for her, not so great for the government, but that is a boon that comes with being a married couple. Again, for our scenario, if Casey and Taylor are not married, they don't get to take advantage of that. And if same thing for Warren and Astrid, there would be huge tax to pay if they were unmarried. So an important factor to consider if you are an unmarried couple. Finally, with respect to the state Medi-Cal program, which can help pay for the cost of long-term care, if you're not married, you don't get to take advantage of some of the more flexible asset protection rules that apply to protect a spouse. So basically 2 individual Medi-Cal plans would likely be needed there, and all of those issues would have to be explored to make sure you were covered in that scenario.
Yeah, and I think, Nick, and those are all, and these are all complex concepts on their own. As Nick's about to talk about, we gave full webinars and talks, and we meet with clients for hours just about individual issues there. I think the key point is to realize that marriage can have a big effect on tax issues. A lot of people don't think of it. It's very unromantic. But when it comes to capital gains, as Nick said, property taxes, estate taxes, big issues that you need to understand. And then there's issues for married couples as well. So anyway, I'll turn it back to you, Nick, that he's going through a lot.
Yes, so on that point, because an unmarried couple cannot rely on the various protections and benefits that come from being married, we have to often engage in some advanced planning for these types of couples. Mark had just presented on both of these topics, the irrevocable trust or a lifetime access trust, and our comprehensive property tax savings plan, both of which are available on our YouTube channel. But 2 key things that would have to be accomplished depending on the goals of the couple. One of the other tax planning approaches, which is sort of ironic, is actually using marriage as a tax planning mechanism. As this meme suggests, if you get married, it would be for the tax exemption. And indeed, there are a variety of exemptions that apply to a married couple, but we would never advocate for marriage to be entered into without considering all of the bundles of rights and obligations that come with that. But nevertheless, it's still a tool in the toolbox, which we would consider as part of any planning approach. Turning away from marriage to kind of an alternative structure, at least here in California, is the concept of a domestic partnership. So here in California, we do still have a domestic partnership program. A lot of people had thought it would go away following the legalization of same-sex marriage or marriage equality here, but nevertheless, we've kept it and indeed actually expanded accessibility to the domestic partnership program, because on January 1st of 2020, it was open to anyone. So previously it was confined to same-sex couples. Now anyone, opposite sex, same sex, whomever, can go and enter into a partnership. It is available in 11 other states and very straightforward. You basically file this declaration of domestic partnership with the Secretary of State, and voila, you're in a partnership, which for state purposes conveys the same legal rights as a marriage. So it is basically a marriage in everything but the name. The community property regime here in California would still apply, even though it's not a marriage per se. And one of the key issues that we talked about a moment ago was property tax. So the Revenue and Taxation Code does have a specific provision allowing a domestic partner to continue to inherit property and not have to worry about a tax reassessment, which is very beneficial. Additionally, if you entered into a partnership and needed to get out of it, there is a streamlined dissolution procedure. If you have been in the partnership for fewer than 5 years and you do not have any children, you can just file a certificate of dissolution and voila, you're no longer in a partnership. So interesting hybrid approach here, but still one for which planning is necessary, given what I'm about to describe here, that from a federal perspective, a domestic partnership is basically two unmarried individuals. So partnership, you have all of the bundle of rights from a state perspective, but you have plenty of issues from a federal law perspective. For instance, you would not have the unlimited marital deduction, as I described in the Casey Taylor example a minute ago, and there would be no portability. So just in a nutshell, portability allows a spouse to use the other spouse's estate and gift tax exemption. Meaning, if you have unused exemption, you can basically tack it on to what your spouse has and pass double the amount to or for your heirs without estate tax. The key is that you have to be married, and accordingly, from a federal perspective, partners are not married, and therefore portability does not apply. No joint income tax filings are allowed, meaning you would have to do, I believe you could do a head of household with the dependent or two individual returns, which does cause an income tax penalty of sorts based on the brackets. Other deductions, like from the sale of a principal residence, are much more complicated to claim. And there are a couple of other federal programs to which a partnership is not able to avail itself, such as adopting a child internationally or sponsoring a partner for immigration purposes. So with these issues in mind, a domestic partnership or entering into a domestic partnership does not solve all the problems, but it does make the situation better if there are no planning documents in place, which is not something we would advocate. But if we play out this scenario again with Casey and Taylor, let's assume that they're partners. And when I say partners for this example, I mean a state registered domestic partner. You filed that certificate of partnership with the Secretary of State. There are some local programs in California. You could be a county partnership for certain purposes, but for this example, you have to be an SRDP, state registered domestic partnership, for these to apply. Here we are again with them, Casey and Taylor, no children, no planning documents. What happens in this scenario if something happens to Taylor? Fortunately for Casey, there are some protections in California law for the state registered domestic partner, who the law treats as a spouse. In fact, the probate code was kind of lazy in how it defined a state registered domestic partner, basically saying that it equals a spouse. So none of the other laws had to be changed. You could just insert that definition in all of the applicable provisions, meaning there would be no property tax reassessment, in that the partner could inherit the property and not have property tax go up. And if there were no planning document, as is here, there would still be an intestate share created in favor of Casey, meaning he would not be left out in the cold with no share of Taylor's estate, because the law would come in and protect him. Nevertheless, there are still estate and federal tax issues that would need to be addressed if for a state registered domestic partnership. On balance, I would give this scenario a math ace, meaning it's somewhere in between. You have some protections, but it's certainly not as good as a core plan would be.
Yeah, just
yes, Mark.
That issue of so domestic partnership helps to solve this, but a big overarching point is, and Nick alluded to this earlier, that if people are not in a domestic partnership, and if they're not married, and you don't have estate planning documents that say my assets go to my partner or my longtime romantic partner, and I empower them to help out, they have no legal rights. They get nothing of your estate. There are sad stories of people that were in 40-year romantic relationships, never married, never domestic partners, where assets ended up going to relatives that they never even really knew because they didn't have the right documents into place. So domestic partnership solves some state issues, but as Nick just mentioned, doesn't solve a lot of federal issues. So kind of a complicated world that we're dealing with.
So to allay some of those complexities, having a comprehensive estate plan is critical. And here there's, I guess, a little more flexibility, because a partnership, depending on the circumstance, could do a joint plan, like for spouses, where you do a joint trust, or 2 individual plans. So that would depend on the circumstances and the assets. But either way, to provide some federal tax protections, we would want to see what's known as an exemption trust of sorts for the surviving partner. Basically, that would allow some estate tax protections to be captured without the availability of portability and the marital deduction. It would also be critical to have the general durable power of attorney and the advanced healthcare directive, which would ensure the state registered domestic partner can make decisions and would set forth important wishes and guidance, as Mark described. So this plan gets you from the mad face to the happy face, and that's what we want to accomplish as we do an estate plan overall. Turning away from the marriage question, one of the important issues where members of the community have to be, have an eye to these points is with respect to the family dynamic. So there are many ways to make a family, whether it's through surrogacy or adoption or informal arrangements. They're all important in making a family, but they do cause different issues from a legal perspective. So the first 2, surrogacy and adoption, those are relatively straightforward from an estate planning perspective, because they confer equal rights and legal status as to the parent-child relationship. So once that order of adoption is finalized, the adoptive family has the same rights as the natural parents would have had. So that can solve some of these problems, but one of the key areas of concern is for informal arrangements. So this would be, if your partner has a child of his or her own, you never adopted that child, but you've treated it as your child, for the child's lifetime. So the law is pretty strict with respect to these issues. If there's not a natural order of parentage or an adoption decree, well, that person's not considered an heir unless you have planning documents that say so. Turning back to our friends Casey and Taylor, let's assume here that they're unmarried again, and we have a minor child now named Sam, who is the child of Taylor only, not adopted by Casey, and again, no planning documents. The same problems apply as described earlier about the assets and how Casey would not have any authority over Taylor and would not be entitled to any share of Taylor's estate. The real challenge here comes to Sam, who would effectively not be given any, even though Casey and Sam may have had a long-standing relationship or a parent-child relationship, the law, if there's no adoption decree, basically severs that relationship altogether. Sam could end up with some unknown relative or in a foster care system. It's a really terrible situation for the minor child when there are no planning documents. Same issue with respect to Taylor's affairs and for property tax. Sam could be in a position where his home is taken away simply because there were no property tax protections, and now you have a minor child who's effectively homeless because of all these problems. So another reason to plan, and if we had planned here, we could have had trusts which had provisions for the non-spouse beneficiaries, so that's Casey, and for Sam, and for any other children that may have existed. Critically, going back to the pour-over will that Mark had mentioned earlier, we would have had guardianship provisions in that document that would have said, Taylor's will would have said, if something happens to me, I name Casey as the guardian for Sam. That is a absolutely critical provision to make sure that Casey, who was effectively a parent, still has some parentage rights and can still step in, to manage Sam's affairs while he's a minor. Additionally, the power of attorney and the healthcare directive, also critical here, ensuring Casey can make decisions, even as to the child. So one of the often overlooked areas is providing for the child if you're incapacitated. So here it would have been critical for Taylor to have said, Casey, as my agent, you can use my funds to support Sam. And absent that, effectively that, the assets of Taylor's Taylor's assets would have been effectively shut off from Sam, even though Taylor would have wanted him would have wanted Sam to benefit from his assets as his child. So having this planning in place again gets you back to a happy place situation, and that's where we want everyone to be. With respect to planning for children, I'll turn it back to you, Mark, so we can talk about some supercharging mechanisms that would work and would apply across the board, no matter the type of family with which we're working.
Yeah, and I think that's the key point here, Nick, is the trust and the incredible tool that I'm about to talk about applies no matter the family structure. This is not limited to just parents creating it for their legally tied children. It can be an uncle for a niece and nephew. It can be someone who has been in a long relationship with someone who has kids, even if that child's not theirs. What the tool that I am talking about is a family protection trust. So this would be, instead of leaving assets to a child or a niece or nephew, you would create a family protection trust for them. You leave money to the trust. You wouldn't actually leave a penny to the child. You leave it to the trust. Now, why would you leave it to a trust and not to your child? It sounds like too much. Well, there's four big reasons. So one, divorce happens in 40% plus case, 40% of marriages and in divorce. If a child divorces and they inherit money, if they commingle that at all, that can get lost to the divorce and to the ex-spouse. If you leave it to a trust, assets don't get commingled, they stay separate, they're not lost in a divorce settlement. Two, if your child is sued, they're in a car accident, they have a bad business deal, something like that, assets they own in their name are fully exposed. If they're in a trust, there's a barrier, there's some protection against creditors or litigants. Someone would have to break the trust to get to these assets. That's a pain, it's a challenge, it's expensive. So it's kind of like an insurance policy against lawsuits and against other claims against the assets. And really powerfully, and this is where you have to wrap your head around multi-generational planning, but the current estate tax exemption is pretty high. It's 12.06 million per person that you can leave to your heirs without any estate taxes. But in the past, it's been as low as $600,000, and any dollar over that, 40% was lost to the federal government. It could go back to that in the future. And if you inherit money and it's just in your name, all the growth in the value of that, if you inherit a house and it just goes up in value, all that growth is part of your estate plus everything you earn. 30, 40, 50% of it can be lost to estate taxes when it goes to the next generation. In a family protection trust, your grandkids or the future generation, the assets in the trust continue when your child passes away for the benefit of the next generation without any estate tax exposure, subject to some limits, but very high limits. So that can save millions of dollars depending on how estate tax laws evolve in the future. We don't know what they're going to be like in 20, 30, 40 years. So why not put this incredible tool into place to prevent those issues? And you might think, well, these are all great. I like the divorce protection. I like the lawsuit protection. I like the estate tax protection. But I don't want to tie my kids' hands or my loved ones' hands with this really complicated trust. It's too much. Well, if you allow it, your child, the beneficiary of that trust, can be their own trustee. So a lot of our clients will say, hey, if something happens to me before my child is 30 or 35, I'm going to name someone I trust to oversee it for them. But when they reach the age of 30, 35, 40, they're going to take over. They're going to be in charge of this trust. So they get to benefit from these protections, and they still get to basically control and manage the trust for their own benefit, meaning they have a lot of flexibility. So this is a tool that ultra high net worth families have been using for generations. And I think this was an article that actually talked about this. There's many articles out there. Ultra high net worth families have been creating, the generic term is dynasty trusts, for a long time. And it's our belief that every family can benefit from these trusts. You don't have to be ultra high net worth. If you own a house in California, it's probably worth doing this. And it should not just be for the ultra wealthy. We should all be able to use these tools. So all the issues Nick talked about, this can be layered in. If you have children, adopted children via surrogacy, or just some member of the younger generation you want to support after you're gone, a family protection trust is an extraordinary tool. It can be added to any of the structures that Nick talked about before to protect future generations or people that you care about for a long, long time. So a big issue. And Nick, why don't you talk about some, so if you have any questions, talk to us about this. We can help you to add family protection trust, no matter your situation. I'd say 2/3 of our clients end up adding family protection trusts when they update their plans. So turn it back to you, Nick, to talk about estate tax issues.
Sure. So, everyone jokes about death and taxes. So no matter your family dynamic, the federal estate tax is there for you. So having an important comprehensive plan, especially depending on the size of your estate, is critical because, as Mark said, the tax is 40% over the assets above the exemption. So that could be a huge tax, because you're losing 40 cents on the dollar to the government. As Mark said, $12.06 million exemption per person. Presently, that number is indexed to inflation. It will increase between now and January 1st of 2026, at which point and on which date it will be cut in half, meaning it will be somewhere around maybe 6.8 at that point per person, which can be doubled between a married couple based on the concept of portability that I described earlier. The challenge with relying on the exemption and just hoping for the best with respect to where it settles is that your estate is likely going to grow faster than the rate of inflation adjustments to the exemption, which means that estate tax could be a concern, even if you don't necessarily think you have all that much money. But particularly if you're an unmarried couple, estate tax is critical to address simply because there's no unlimited marital deduction and there's no concept of portability that would apply to you. Accordingly, if your net worth exceeds $5 million for an unmarried couple or $10 million for a married couple, it's critical to take action now. And I say that, the planning that we typically implement from an estate tax perspective is complicated, it's complex, and it takes time. So waiting until November 2025 is not a good idea. The sooner the better with respect to this planning, because it's a real issue and there are huge funds at stake if no planning steps are taken. Indeed, it's use it or lose it. The IRS came down with regulations that said that if you don't use all of your exemption before the January 1st, 2026 date, you don't have any after that point. The math is a little bit complicated, as my explanation just may have sounded, but basically the advice is to try and use as much of your exemption as possible before it's gone. And how would we do this? Well, we have a whole host of tools in the toolbox, a lot of which are described in Michael Gilfix's book that's featured on the screen and available on Amazon and through our website. But most of the strategies typically will focus on something like a spousal lifetime access trust, which could just be a lifetime access trust if there's no spouse at issue. Capturing valuation discount on transfers, using other types of specialized trusts based on the wishes of the client, along with engaging in charitable planning and family foundation development, which can help to not only allow for some control and enjoyment of the assets, but also benefit your goals or your philanthropic goals that might apply. Property tax. Do you want to talk about property tax, Mark, or do you want
Sure,
me to?
yeah, I think this is, if you're in California, if you own real estate for a long time, you can probably appreciate that Prop 13 means that your property taxes have stayed low. Prop 13 limits annual property tax increases to 2%, even when the value of a property is going up 10, 15, or 20%. So over time, that means that if you've owned a property for a long time, your property taxes are probably a fraction of what they would be if you were to buy your house at its current fair market value. We have many clients who have houses worth $3 million, where if you were to purchase a $3 million house now, you're paying $36,000 a year in property taxes. If you've had it for a long time, maybe you're only paying $4,000 a year, $5,000 a year in property taxes, a tiny fraction of what your fair market value is. Now, this is a big deal because previously, so Prop 19 passed, it became law last year. Previously, parent-child transfers of a primary residence were protected from a property tax reassessment. So kids would take mom and dad's very low property taxes. Prop 19 changed this. So now there are extreme limits on what can go from mom and dad to kids protected from property taxes. Big picture, and we have whole webinars on this. Check out our Gilfix Law YouTube channel. Parent-child transfers of real property are no longer protected in the way that they used to be. So there can be huge increases in property taxes when mom and dad pass away. And if you want to leave your home for the benefit of your kids, this is a big deal, because can your kids afford a $40,000 a year property tax bill if taxes went up to that? Or can they afford a 1,000% increase in property taxes? So, and rental properties, by the way, there's no protections either. So Prop 19 eliminated any parent-child protections for rental properties outside of the primary residence. Bottom line, if you want to leave any assets, if you're lucky enough to own multiple pieces of real estate in California, you need to be aware of this. Prop 19 means that property taxes go up by 500, 1,000, 10,000%. We've seen that in some cases for clients who want to leave assets to their kids. We can protect against this. And as Nick talked about, if there's a domestic partnership Or if there's, sorry, not domestic, if people are not in a domestic partnership or not married, this can be an issue when you pass away and your property goes to your significant other. If you don't have that, if you're not married, if you don't have a domestic partnership, that reassessment can happen even if you are leaving your house to your longtime companion or partner. If there's no legal relationship, full reassessment of property taxes. Same issues if it's a kid who's not adopted, if just someone you consider to be a kid, property tax is fully reassessed when a property passes from you to that loved one, unless you take steps. And so our firm has developed several tools to deal with Prop 19. We have a webinar that Nick alluded to on Prop 19, protecting Prop 13 low assessment. So we can help, but you have to be aware of property taxes. It's a big, big deal. It can be tens of thousands of dollars per year. So Nick, why don't you tie it all together?
Yeah, sure. So lots of issues at stake here, and there are lots of family dynamics where different issues are going to be brought up and different issues are going to apply. And that's why we as a firm, we pride ourselves on not taking a one-size-fits-all approach. We understand that each structure is different, each client has different goals, and each dynamic is going to have different issues. But our goal here is to tie it all together, go through a comprehensive analysis, understand your goals, understand your family dynamic, and tie everything together in a comprehensive plan that protects against all these issues and otherwise captures the maximum benefits that we can capture, pursuant to an estate plan. And that gets us to how we can help. So critically, we want to get to know you. All of our clients, we value ourselves on having a personal relationship with them and understanding what issues are on their mind and what critical legal issues might apply that they might not be aware of. That's why we're there, to identify those issues. And usually it involves expert analysis of any of the issues that might apply. And some of the ones we discussed here: what is the marital status? What is the family dynamic? Are there children? Do we need to have a family protection trust for them? Do we need a special needs trust for them? Are there concerns about creditors? What about property and capital gains and estate tax? The big three that are always present no matter the family dynamic. And as I mentioned, special needs issues. We've been serving the special needs community basically as long as we've been around. It's a core area of our practice and didn't get too much attention in this webinar. I know we have other webinars available on our YouTube channel, but a critical component of any comprehensive plan. What a key step is for you to meet with us. We can't help you until you meet with us, other than giving you the information we've given you here. And we always encourage you to act now to protect your family. How you can reach us? Here we have some contact information. We have our phone number. If you reach out to Nadia, who's our case manager, she can help you set up an appointment, or you're welcome to leave your name and contact information in the chat and we can contact you.
Yeah, and I think, as Nick pointed out, that there are a lot of issues swirling around, and you can take shortcuts and try to just do simple stuff. But if you miss one tax issue, one asset protection issue, that can be hundreds of thousands of dollars. And there's no one, whether you're consider yourself high net worth or not, no matter your family structure, whether domestic partnership, married, longtime romantic partner who you don't have a formal arrangement with, so critical to sit down with someone who understands how it all fits together. And what we want to do is just learn what your issues are and your goals are and work from there. We'll fill in the legal blanks. You don't need to understand how all these issues fit together. That's really our job. And this is an educational webinar. This is not meant to be legal advice. We can't provide legal advice unless we really are working with you formally. So reach out. Gilfix.com is our website, for those of you who don't know us. And the way that we typically do meetings is when we sit down with someone to plan, we bill hourly at our whatever the attorney's hourly rate is, because we're there to serve you. From that moment, we typically have flat fees to complete a plan, so you know exactly what the cost would be. If you have questions about how we do things to make sure that we're a good fit, we're happy to set up an initial 15-minute free call. Reach out to our phone number here, to Nadia, or just via our website to request that, to set a meeting. If you're ready to get started, I say set a meeting. We meet with you via Zoom, in person, over the phone. Again, we serve people throughout the state of California, and we all work as a team. So we have a combined 100+ years of experience in this area between our attorneys, and we all work together. So if I'm not sure of something, I talk to Nick about it, or I talk to Michael Gilfix or Francis La Poll or Renee Conrad, another awesome attorney on our team. So it's a privilege to get to know everybody, or I hope you got a lot out of this. Please share this. If there's anybody in your circle who is facing these issues, please share this webinar with them. It's on our YouTube channel, or it will be on the Gilfix Law YouTube channel. Like it, subscribe. We really hope you get a lot out of this. We want to spread the word. We want to empower you, because right now, you know more than 99% of the population about these issues. It's okay if you don't get all of it, but the key is you can take action. So if you have questions, set a meeting with us. Let's discuss it. Let's figure out how to create a great plan for you to protect yourself and your loved ones. We don't want you to get stuck in the courts or your assets to go somewhere you don't want them to go, which can happen if you don't plan ahead. So I want to thank Nick for giving this fantastic presentation. It's a privilege to get to learn from Nick every day, because I learn every day from Nick. And again, it's so tricky to deal with all these intersecting issues, but that's what we do day in, day out. So hope you got a lot out of this. Reach out to us. We're happy to chat and serve you and your family, no matter what your family structure is. I think in honor of Pride Month, we really pride ourselves on having solutions for every type of family and serving every type of family out there, because there's no one size fits all approach, just like there's no one size family. So on that note, Nick, any final thoughts?
No, do we get any questions? I'm not able to see for some reason.
Yeah, we had questions about the process for how we can help out.
Oh, sure. Okay, cool.
Kind of, yeah, and actually another question was just clarifying about domestic partner versus marriage. And I think the question is like some confusion about how that difference. It really goes to federal law. So domestic partnership for California state purposes, if you get a lot of legal protections, you're in pretty good shape. But estate taxes are a federal law issue. So when it goes to estate taxes, that's if any are owed, a stepped up cost basis, meaning when someone passes away, if it's in your estate, your loved ones, wherever it goes, can sell those assets later for little or no capital gains tax exposure. That's a federal tax law issue. So it gets a little bit complicated depending on your situation, but we can help no matter what. So I think that really covers
Yeah, the
it.
interesting thing on that particular concept is that the state has adopted specific rules that apply in state to domestic partnerships that the federal government has not applied. So it's really two systems that would apply, and there's also an income tax consideration from the federal perspective as well. So that is probably the more complex of all of the scenarios we played out, but still a valid way to have a relationship, and accordingly planning should be done for it.
Yeah, so if you have a plan and you're not sure about it, we can take a fresh look at it and see if updates are needed or what you might want to do. If you don't have a plan, set that meeting. We can help you out. So I think on that note, we're going to wrap things up. But thank you so much for spending time with us here today. Again, share it, like this video, let people know, spread the word. So many people don't understand these issues and they need to. So you're ahead of the game. Let's help as many families as we can, and I hope everybody's staying safe, sane, and healthy, as my mom likes to say. And on that note, we'll talk to you later. Thank you so much for watching. If you enjoyed it, please share it, like the video, subscribe here, and stay tuned for more free legal estate planning and financial educational videos.